This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today I'd like to speak about what happens when a person buys an auto liability insurance coverage but has no license. Because if you have no license, you have no coverage, and a court will always enforce the exclusion for any losses when the driver is unlicensed. In a case where Great Western Casualty Company, DTAC LLC, and Matthew Allen, at times always referred to as Great West, appealed the grant of summary judgment in favor of Founders Insurance Company, declaring that Founders was not obligated to provide coverage under an automobile insurance policy procured by Brian K. Gates, Jr. In Great West versus Founders, a December 9, 2022 decision of the Court of Appeals of Indiana, the dispute between the parties was resolved. On June 24, 2020, Gates applied to Founders for automobile insurance coverage. In the application form, Gates indicated that his driving privileges were suspended in the state of Indiana and he was seeking SR22 insurance coverage as required by the state during the driver's license reinstatement process. Founders issued an SR22 policy which included an exclusionary provision applicable if Gates failed to obtain a valid driver's license within 60 days. 76 days later, on September 8, Gates was driving his insured vehicle when it collided with a tractor-trailer driven by Mr. Allen. The tractor-trailer was owned by DTAC LLC and insured by Great West. At that time, Gates had no valid driver's license. Gates had paid premium to Founders for the 3 months before the accident, and Founders after September 14, 2020, when he failed to pay, canceled the policy for non-payment of premium. Great West sued Gates for damages resulting from the collision. Shortly thereafter, Founders sued for declaratory judgment, seeking a declaration it was not obligated to provide insurance coverage for Gates, pursuant to an exclusion in the policy because Gates had been driving without a valid driver's license at the time of the collision. The trial court entered summary judgment in favor of Founders and directed the entry of final judgment. Great West, of course, appealed. Summary judgment in Indiana is appropriate if the designated evidentiary matter shows that there is no genuine issue as to any material fact and that the moving party is entitled to a judgment as a matter of law. The interpretation of an insurance policy is primarily a question of law for the court, and it is therefore a question which is particularly suited for summary judgment. Although ambiguities are construed in favor of the insured, clear and unambiguous policy language must be given its ordinary meaning. There was no dispute of fact between the parties. Rather, the appeals sought a decision whether Founders is entitled to summary judgment as a matter of law based upon an exclusionary clause in the policy. That clause read, quote, "No coverage is afforded under any part of this policy if at the time of the accident your insured car or a temporary substitute car is being operated by a person who A, is not a licensed driver, or B, is without a valid driver's license, or C, whose driver's license is revoked or suspended, D, whose driver's license has been expired for more than 30 days, or E, is in violation of any condition of their driving privileges, or F, is not legally entitled to drive under Indiana law," close quote. Gates was driving without a valid driver's license on the date of the collision. The trial court concluded that by the plain terms of the policy, insurance coverage was excluded. Great West does not argue that the exclusionary clause of the policy is ambiguous, but rather that it should be given no effect under the circumstances. Specifically, Great West argued that Founders waived its right to enforce the exclusionary clause because it conducted no investigation as to the status of Gates' driver's license before taking his final premium payment. The Court of Appeal noted that the general rule is that if a party to a contract performs acts that recognize the contract as still subsisting, such as accepting rent payments, specific performance of the terms of the contract is waived, and there can be no forfeitures. This rule is founded on principles of common honesty. A landlord cannot take the position a lease is valid for one purpose, such as collection of rent, and yet declare it invalid for other purposes. Great West has identified, however, no like circumstance, and indeed no dispute of material fact. It was uncontested that at the time Gates tendered his August premium, the policy remained in full force and effect. Founders did not contend otherwise. Founders had issued no notice of cancellation at the time and did not do so until Gates failed to tender a September premium payment. The court concluded that the right of a third party to recover through liability insurance is not absolute. The source and means of recovery is grounded in the insurance contract itself. Since the policy contains an unambiguous exclusionary clause plainly applicable to the uncontested facts, the Court of Appeal could discern no basis upon which the plain language of the exclusionary clause should be disregarded, and concluded that Founders was entitled to judgment as a matter of law, and that there was no genuine dispute of material fact, and thereafter affirmed the decision of the trial court. In my opinion, you must remember that insurance policies are contracts. The terms and conditions of the policy, if unambiguous, must be applied as written. Since Gates was unlicensed at the time of the accident, the clear and unambiguous language of the policy and the injured party has no rights against Gates' insurer. They can, of course, get a judgment against Gates and collect from his assets. An injured party has no right to recover from the tortfeasor's insurer. They only have the opportunity to do so if the policy provides insurance coverage for the injuries claimed. It's silly almost for an insurer to sue another insurer when it could read the policy clearly and find that there was no coverage. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can also subscribe to the blog posting so that you learn of all new blog posts on a daily basis, since I issue a summary or digest of an insurance case at least 5 days a week, sometimes more. You can also subscribe to the videos on rumble.com or youtube.com so you can receive notice of each video as they're published. If you found these videos and blog postings to be interesting or useful to you or your colleagues, please let them know so that they can also subscribe. And also consider subscribing to the paid content at locals.com and substack.com. Thank you for your attention.